And could we have quiet? Could we have quiet? I'm calling the meeting to order, okay? This is August 22nd, the Tiverton Board of Review, and before we get started, I just want to put some preliminaries down on the record. This matter has been continued multiple times from December 6th, January 10th, 2024, February 22nd, 2024, March 6th, 2024, March 20th, 2004, April 29th, 2004, May 29th, 2004, and lastly, July 17th, 2024. And this is a matter, I'm not going to read the entire petition into the record. I think we all know why we're here. This relates to the Seasons application for a number of special use permits related to the proposed opening of a gasoline filling station, a drive-through window, and signage that doesn't conform to the requirements of our ordinance. I'd like to just state who's up here for those of you who aren't frequent flyers here. My name is Lisa Gescheit, and I'm the chair of the board. I rule on questions of evidence and scheduling, that kind of stuff. And I have no greater vote than anybody else has, but I try to run the meeting in an orderly fashion. To my left is Todd Romano, who's our town solicitor, who's here tonight. To his left is George Alzabak, who's a full voting member. And to his left is Edwin Schober, who's an alternate. And are you sitting through all of this? Yeah, you have it, okay. To my right is David Collins. To his right, Jennifer Kavanaugh, followed by Jay Jackson. And our stenographer tonight is Sydney Tagney, T-A-N-G-N-E-Y. Our regular note taker is not going to be available tonight, but she did indicate to me that she would listen to the tape and transcribe the minutes from that audio recording. And I believe when we left off that was it your witness, counsel, that was testifying?
Yeah, it'll be Tivertonvideos witness.
Okay, fine.
Yes.
Madam Chair, just as a procedural matter, under your rules, there's a rebuttal period. Just to remind everybody, we've reserved the rebuttal in the papers
Right.
after we're done with summary memoranda, et cetera.
I absolutely understand that. And I was going to bring that up before the end of the meeting in terms of what we can expect down the road, because we don't know how long we're going to be here tonight. Obviously, the defendants get to continue putting on their case. You get cross-examination. The public and the board get to cross-examine the witness. And at that point, if there is any rebuttal at the time that the defense rests, then we'll schedule the rebuttal. After that, the public has a right to be heard on the merits. You know, how do you feel about this? How do you think it violates our ordinances? And what are your complaints? And so that'll be a period for a public hearing. And at that point, obviously I haven't talked about this with anybody, but it would be my request that the public portion be closed and that council submit, I don't know if you want to put in live rebuttal, but assuming you don't, I would want to have memorandum of law, proposed findings of fact in a memorandum of law that cites to the voluminous record, because I've read some of the transcripts. I haven't read all of the transcripts because they haven't been available to us. And you're more familiar with your case and the record because you have the transcripts and you have your point of view to argue. So I would just propose to the members of the board that at some point we submit the papers on simultaneous filings. And if there's anything you want to argue in final, fine. I think at some point the board has questions about hours of operation and delivery times and things of that nature that we'd like to clarify before the record is closed. But you know, at this point, I think, I know I'm looking forward to having a, you know, a very, it doesn't have to be, you know, the Nobel Peace Prize for literature. It just has to be what lists the different grounds, what the particular subsection you want and you're arguing for, what exhibit number that you have agreed on can support it, and, you know, do it in bulletproof, you know, bullets, and direct us to the transcripts so we can do our own research. And yeah, I know there've been some issues as far as legal principles that you're gonna wanna argue. Put them in the memo, and we'll rule on it, you know, before we you know, go any further. But, you know, I think we should, at this point, you know, the hearing is getting so long and drawn out that you can't expect a volunteer board to get transcripts that aren't available and read thousands of pages, when you're in a much better position to direct members of the board to why you think the record supports your point of view. I don't know how everybody feels about that, but that's what I think would be an orderly way of doing it, so we can address all the points serratum as they're listed in your, is that agreeable to everybody?
Yes,
Yes,
absolutely.
yeah, we have no objection.
Okay.
And we also will abide by your earlier request that we'll have a single list of exhibits.
Absolutely. I mean, I'm hoping that you guys can agree on the record and cite to pages that are in the record that you both agree on, you know, and direct them to us, or attach a copy of the page you're referring to. You know, that would be really helpful. We don't have all the transcripts. Some have been sent to us, some of them haven't been printed out, and I don't think any of us have the ability to put, you know, to print out, you know, 300-page transcripts. And it's a big, it's tough for our, you know, limited stenographic and secretarial staff to make all these copies.
I doubt we'll have any problem agreeing on the record.
Okay.
We did that for the appeal of the planning board decision that you
Okay.
heard,
So I make a motion that the board agree to this schedule. I think we can give council as much time as they need to go through the record. I mean, this is not something you can do overnight, you know?
Yeah.
All
So
those in
moved.
favor? Okay. Everybody were there affirmative? So I think it's unanimous. We'll work something out, and we'll talk about it step by step, so you don't have to, you know, have expenses that, you know, are not gonna be worth expending, so we can do it orderly in a fair way. Okay?
Tonight, Madam Chair, we'll have just one expert witness. We do have another lay witness who we may want to put on, but we will only have the one expert.
I had one question in terms of, I know we've had a very active audience participation, and I know that there's a Preserve Tiverton group. I don't know who your members are, and maybe we should know.
We started to ask them to identify themselves for the record when they, if they come up to give their comments or testimony, as the case may be.
I mean, maybe you can just give us a list of people that you're representing, so we know where everybody is on the page and if they're represented by council. Okay?
Can I ask one question before we get going? This is just for the audience, and just concern of mine for, it's a vacation month, and I would love this meeting to go pretty short, because some of the audience are not here, because not by choice. We have a choice to go back and vote and read. There's a lot of people, no one asked me this, I'm looking at the crowd, and there's a lot of neighbors and faces I'm not seeing. They've got kids, they've got vacation. I would love this to be short, to the point, and we leave early, because I do not want a neighbor to miss something really they're supposed to be here.
Okay, we'll have a
And
vote on
talking
that at
about
the
not
appropriate
having the
time.
records, they don't have the records.
We'll have a
Thank you
vote
for
on it.
that. I have to say, one of my primary client is not able to be here tonight. I mentioned it earlier because she's ill.
Okay.
So I would second that, depending on how council feels, that we do what we need to do tonight to make it a good working evening, but not try to get every last.
I'm not sitting here playing beat the clock until 10 o'clock. Believe me, if
Thank you.
everybody can agree to
Thank
an
you.
early
Thank you.
departure, there's not going to be any argument from me.
Thank you for allowing me. Thank you.
Madam Chair, while I haven't had an opportunity to consult with my sister here, Attorney Karen Benson, I suspect that our post-hearing memorandum will be a joint one.
Okay, that's
As-
fine. Why don't you identify yourself for the record before you?
Yeah.
We have a new stenographer who might not know who you are.
Yes, Attorney Christopher Tiverton for Tracy Haywood. And these two members of the council. So this evening, I'm going to have our witness, Peter Friedrich. He's our planner expert. And if you could come up here and sit here, Peter. And I will endeavor to be brief. I'd like to go home early as well.
Now, is this a gentleman that you, council, have agreed to qualifications or not?
Yes, we submitted the witness and his resume.
That's right. The applicant has no objection to Mr. Friedrich as a planning expert.
Okay, thank you. Record reflect a joint stipulation.
And just to be sure, you have a copy of his report and his CV that was submitted, I think, in July.
Bear with me, I've got
Sure,
an
no.
entire filing cabinet in the trunk of my car.
I think the zoning officer can attest that I did drop it
I'm
off
sure
in
you
July.
did. I'm not doubting it.
My clerk could, but she's not here.
Oh. I dropped it off with you, personally, me and you.
I don't recall the document was.
Oh, okay.
This is stacked this time.
Okay.
And we stipulate we have it, and then if we don't, throw his testimony.
You have a copy, Bob?
Yes.
Okay.
If there's anything in there that you want to bring to my attention, I mean, I'm sure I reviewed it.
No, and I
Whether
think
it's in
maybe
my-
that's the best way, that if you don't have a
Okay.
copy, I'll get it to you, but I know that,
And Madam Chair, we also stipulate that Mr. Friedrich's resume and his report, although it's dated July 2, 2024.
I'm sorry, you stipulate to, what is that again?
That Mr. Friedrich's resume and his report dated July 2, 2024 was submitted.
Okay, thank you very much.
okay, so, Mr. Friedrich, just for the record, could you please state and spell your name for the stenographer?
Yes, Peter Friedrichs, Peter Friedrichs.
And you need to swear him in?
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth so help you God?
I do.
Thank you.
Okay, Peter, I prefer to call you that. Peter, just start out just by giving a brief summary of your education and training. You are certified through the American Institute of Certified Planners,
Yes,
and you've been employed as a planner in Rhode Island communities, including Newport and Central Falls.
yes,
And your employment includes providing planning consulting services.
yes,
And you have work and educational experience with historic structures and districts, including getting structures and districts listed on the National Heritage Register.
National Register of Historic Places, yes.
Thank you. And while you're not testifying as a lawyer tonight, you did graduate from law school and you took the bar and you're awaiting those results now.
Yes,
And
My
you,
sympathies.
thank you.
and you just had a baby, so you got a lot going on.
Yes,
You have a company, a planning consulting company, correct?
yes,
And currently, this is just some of the new things that I just found out, that you are working with Conley's, Mr. Conley,
Dylan,
Conley's law office right now as
Yep.
as an intern.
yes,
Yeah. And you're also working with the town of, the city of East Providence, with Mr. Pimentel, I guess, doing a complete overhaul of their zoning ordinance. Is that
yes.
correct? Okay.
Correct,
So in your professional roles, your responsibilities included understanding municipal comprehensive plans, correct?
yes,
And in fact, you've worked on developing comprehensive plans.
yes,
And you are familiar with the Tiverton's comprehensive plan.
yes,
And in your roles, you were responsible for understanding municipal zoning ordinances, correct?
yes,
And you're familiar with the Tiverton's zoning ordinance and its zoning districts and special use permit criteria?
yes,
And ultimately, you have responsibilities or experience in your duties to determine whether a project is consistent with municipal comprehensive plans and zoning ordinances, correct?
yes,
And you've testified as an expert in this capacity in the past.
Not in the town of Tiverton, but in other municipalities in Rhode Island.
Okay.
May I
So,
interrupt you for 1 second? Can you speak to the mic?
oh, I apologize, yeah.
That's not for me, for everybody behind.
Okay, I'll speak, yeah, I apologize, yeah. Now, the project issue is the Colbia Seasons application, and your report indicates that you've assessed whether this Colbia Season application is consistent with the Tiverton's Comprehensive Plan and zoning ordinance, correct?
Correct.
And if you could just describe briefly the method you used to reach your opinions as to the application's consistency with the comprehensive plan and zoning ordinance.
Sure, so what's in front of the Tiverton Zoning Board of Review here is 3 special use permit applications. Those have criteria listed in the zoning ordinance, and in order to grant the requested special use permits, the Zoning Board of Review is required to affirmatively find that the application meets all of the required criteria. So I reviewed those criteria. One of those criterion is consistency with the comprehensive plan. So that required a review of the comprehensive plan and making those determinations. And I relied on general best practices, planning expertise, and how comprehensive plans and zoning ordinances are drafted in Rhode Island in compliance with the enabling acts from the Rhode Island legislature, and then how they're implemented throughout the state.
And you talked about the 3 special use permits. That's one for non-conforming signs,
Yes.
one for a vehicle station, and another for the drive-through restaurant?
Yes,
Okay. And in this assessment of consistency with the plan and the ordinance, you assessed Colbia's project proximity to neighboring uses, including the residential uses in the Osborne Bennett Historic District?
yes,
And in preparing your report and for tonight's testimony, you reviewed the applicant's expert witness reports and testimony via transcripts and/or videos of the several hearings in this matter?
yes, and I've been to a few of the hearings in person.
Okay. And again, your assessment of the consistency is described in your report, which has been submitted to the board. Is that correct?
Yes.
So now I'm going to just go over a few things about your assessment. Now, with respect to the special use permit for signage, there's 2 different sets of criteria that apply to the signage. Is that correct?
Correct.
Could you tell us a
May I
little?
ask a question on that? A legal question?
Yes, to our counsel.
Yes.
To him?
The second set of requirements that he's talking about, I've never seen before. And they're not listed in the online set of criteria. I'm wondering if in fact they are real, and if they are, if they really apply to us. And, you know, there may be something new that I'm not aware of. You're not, you don't.
Sitting in.
I know we
But-
have those, and I know that they're, I copied them at one point, now whether I took them out tonight.
If it's helpful, I think I recall that they were in the applicant's presentation, the written presentation. So I, not to speak for the applicant, but I think they're aware that they're, of those
I know
criteria.
I've read them, so,
Read them in our ordinance or
yeah,
in here?
I read them in the ordinance. And do you,
I mean, if you go to the online set of ordinances, it's not there, I checked. That's
I
why-
found them because I knew what the citations were.
Well,
Yeah.
we were given that too, and I
Yeah.
couldn't find them there.
Is it possible the zoning ordinance has been changed?
Well, that's what I'm asking.
That's what happened.
Yeah.
I'm trying to figure out what revision
So,
we're
Mr.
working
Collins, when did you look online?
on. Last week.
There was the major revisions in December of 2023, which may have changed what you're looking at.
Were you looking under the municipal code on the computer?
Yes.
Yeah, because I printed them out. I mean, I saw them at one time. Whether I can put my hands on them right now, I'm not sure I can. But, do you have, Mr. Stolzman, do you have them?
If it's helpful.
If you could just give us the citations.
Yeah, it's,
Well,
we've been consistently referring to Article Roman numeral 16, Section 2 of the ordinance that has additional criteria for parking.
Signage.
I'm sorry, for signage, I apologize, signage. And,
There were like 3 things.
Yes, and they're correctly, we have no objection and agree that they're correctly articulated in page 2 of Mr. Friedrich's report.
It's gonna go through them anyway. I mean,
Yeah.
they're not gonna do that. So I'm gonna go through them and see.
He's going to recite the standards, are very brief, the article and the section. So with respect to the special use permit criteria, unique and specific to signage, could you just recite them for the?
I can, and if it's helpful for the board, an application is subject to the ordinance in place when it applies. So I believe that this language was the ordinance at the time that this application was submitted, so it's subject to these criteria that may no longer be in the zoning ordinance.
Well, I think they were, I thought we all agreed that they were the ones that applied. Was there any dispute about which laws applied, council?
No, you're correct, Madam Chair.
So if you can continue, just, give us the section, the article, and for the benefit of the members of the board, could you just recite those?
Absolutely.
3 criteria?
So these 3 criteria are in Article 16, and it's Section 3F, so it's a little further down than the general 6 criteria in Section 2. And these 3 criteria are, number 1, that the establishment of the sign in a completely conforming manner will result in significant damage to the associated business. Number 2, that the establishment of a sign which is not conforming by size will result in a clear visual improvement to a site by virtue of its replacement of an existing non-conforming sign. And number 3, that the location of the sign on a site in a non-conforming manner is necessary to achieve its intended visual effect.
So with respect to criterion 1, that being that the establishment of the sign in a completely conforming manner will result in significant damage to the associated business, what was your assessment?
So I'm appearing here on behalf of some objectors, and the applicant has the burden of proving that the criteria are met. My expertise comes in if there's kind of a base meeting of that standard, then you compare expert testimony, which expert has the better testimony, and the board can then make its determination. Here, there hasn't been any evidence from the expert that they're meeting this criteria, so
Can you repeat the criteria once again?
yes. The establishment of the sign in a completely conforming manner will result in significant damage to the associated business. And, I think just generally, if I were to provide that testimony, and just having some understanding of how Cobia operates, there's branded entities operating Seasons and Shell. They have a design package, and I think what the Tiverton requirements don't deviate substantially from those maybe typical design package that the applicant has, but nevertheless, the applicant has decided rather than to change its signage, it is availing itself of this application to try and provide non-conforming signage.
And with respect to criterion number 2, the establishment of a sign which is non-conforming by size will result in a clear visual improvement to a site by virtue of its replacement of an existing non-conforming sign.
There's no sign on the property currently, so I don't understand how the applicant could meet this criterion.
And then lastly, the third criterion, that the location of the sign on a site in a non-conforming manner is necessary to achieve its intended visual effect.
Again, there's no evidence from the applicant of meeting this criterion. It's just stated in the applicant's written report from its attorney, and there's no expert evidence supporting that. There's no evidence at all supporting that conclusion. So it's not really my job to state why it wouldn't meet that, but you know, maybe there's some necessary thing here to alert people in some substantial way about, you know, a gas station and convenience store, but this is the only business that would be in the area, so it's pretty clear what's going on there, and I guess, you know, some signage is possibly needed to identify what's going on, but, you know, this typical strip signage, to me, is just over the top, and, you know, not necessary for these special use permit criteria.
Okay, so staying on with the special use permit for non-conforming signage, there are the 6 general criteria which apply to all special use permits. And if you could, for the benefit of the board, just briefly recite those 6 criteria.
Sure, so again, this is Article 16, Section 2. First criterion, the public convenience and welfare will be served. The second one, somewhat similar, it will not be detrimental to the public health, safety, morals, or welfare. Number 3, it will be compatible with neighboring uses and will not adversely affect the general character of the area. Number 4, it will not create a nuisance in the neighborhood, nor hinder or endanger vehicular or pedestrian movement. Number 5, it will have adequate provision made for water service, sanitary sewage disposal, and fire protection. The board may accept reports of the State Department of Health and registered professional engineers, land surveyors, or sanitarians as proof of the adequacy of these facilities. And number 6, it will be compatible with the comprehensive community plan of the town of Tiverton.
Okay. And so I want to sort of stick with the area of your expertise. Now, there are 6 criterion making up the total of criteria for a special use permit. And you indicated there's somewhat similar between those 2 first criterion, the public convenience and welfare will be served, and it will not be detrimental to the public health, safety, morals, or welfare. So there's been discussion here at this board about what constitutes the public welfare or something that would be detrimental to the public's welfare. In your opinion, as a planner and all the experience that you have, are you familiar with factors that can determine whether something is adverse to the public welfare?
Yes.
And if you could tell me what those are.
So I think welfare, you know, in the context of land use and planning, community welfare, what's in criteria 2 is pretty close to what's generally understood as the police power of a government to try and regulate its community to improve it. And so welfare is, you know, physical, emotional, and, you know, tied into that is financial welfare, because the more disposable income you have, the more things you can buy and services you can get to make yourself feel better and support things that you're interested in.
So in your opinion, if a project were to decrease the value of your property or reduce your reasonable use and enjoyment of that property, would that be something that would take away from your well-being?
Yes.
And if it took away from your well-being, it wouldn't be in furtherance of the public welfare, is that correct?
So these criteria use the word public, so it seems to me like the town council in drafting this wanted the zoning board to look broadly at the public. So it's not just one person's welfare, it's the public as a whole, and it's up to this board to define what the public is. Certainly, there's a notice area, there's a, you know, visible area within this proximity of this site. There's people that frequent this site. So I would encourage the board to look at this broadly. And I think that includes also the applicant, the property owner. They have rights, and that should be considered by the board as well.
And
So, can I just ask a question? Are you saying that the individual people that are living in the environment, the immediate environment, they're the public we should be looking to determine?
I think they're part of it, yes.
And is that part of some industry standard that says that?
So there's the State Enabling Act requiring 200 feet of notice. When you're doing planning, you're generally looking at the kind of quarter mile, half mile radius. 200 feet is much less than that. And your neighbors are the ones that have to live next to, this new use every day. So they're going to be more impacted than those that, are down the street or around the corner.
Okay, thank you.
And so in that context, you've visited this site, is that correct?
Yes.
And generally, well, not even generally, the uses within 200 feet of this project site is used by residential dwellings. Is that correct?
Having not reviewed the abutters list recently, I can't say with absolute certainty, but certainly looking at that site, it appears that everything in the vicinity is residential, yes.
Okay, so with respect to criterion 1, could you explain your assessment of criterion 1 on this project?
All right, so we're talking about signage.
No, we've moved on from signage, I think. Oh, I'm sorry, yes,
Yeah.
signage.
Could you
yes.
identify what the
Yes.
question was pertaining to, because I was confused
Yeah,
as
so
well.
we're still on signage. We went through the specific signage criteria, which are 3. Now we're going through the 6 general criteria that applies to all special use permits. In this case, we're applying those 6 criteria to the special use permit for the sign.
Correct. And again, this first criterion is that the public convenience and welfare will be served. And what we're looking at here is the non-conforming signage versus conforming signage. And so this non-conforming signage that's requested by the applicant above and beyond what's allowed, I think it demonstrates some convenience to the applicant. They probably have to spend less money designing conforming signage if it's their general operations. Perhaps the signage is better at communicating to the passerby this business. I don't know that we've heard evidence of that, but I guess that's possible. I think there's a lot of drawbacks to this proposed signage. I'm not really understanding why the signage needs to be illuminated. I think there's a lot of signage. Again, this is the only business in the immediate area. It's the only gas station probably within a quarter mile. So there isn't really a lot of competition that this applicant is needing to differentiate itself from.
Okay, and with respect to criterion 2, could you tell us what your assessment is on that?
Yeah, so we heard some testimony from some of the applicants, experts, particularly thinking of Mr. Hool, and I think there was some good discussion there. And I would defer to other experts who've talked about some of those issues. But again, this is similar to that first criterion. I think it's a bit of a stretch to bring in public health and safety. But it just seems like too much signage. Over signage has been shown to kind of raise your awareness. It ties into how casinos are designed to make people feel at a heightened level of interest, and that might be successful for driving sales at this business, but when you're countering that to, what the town of Tiverton is, it just seems like it's asking for too much.
And so there are people who live, directly across the street on Sousa from this project, directly across the street from Main Road. Have you seen any renderings to help you determine what these folks might be seeing at night?
No.
Okay, with respect to criterion 3, what's your assessment on that?
So criterion 3 is that the proposed use will be compatible with the neighboring uses and will not adversely affect the general character of the area. Again, this is non-conforming signage. We've talked about the residential uses, abutting this property and in the vicinity. There is other property, vacant property, and it's not really prudent to hypothesize about what is there in the future. We can really have to work with what's at present, and I'm not understanding why you need non-conforming signage when there's no competition. This is, if you were a board game shop, sure, but I think everyone knows what a gas station is. Most gas stations have convenience stores. Certainly the fact that there's some sort of restaurant, I think is an additional amenity that would be good to notify the public about, but we haven't heard from the applicant, what kind of signage is needed to support that. And then, I also want to talk about the Osborne Bennett Historic District, which is within view of this property, and vice versa. And it seems like that's an important asset to the town. And we can go into it some more, but basically, a 21st century gas station with all of these additional uses is not supportive of the historic asset that is the Osborne Bennett Historic District.
So I just want to unpack that just a little bit. So when a structure or a district is going to be listed in the National Register, are there considerations other than the historic buildings? Meaning, do you consider the surrounding area and when that's,
There's been no evidence at all about that,
about what?
about applications for historic,
No, this gentleman here
yeah.
is familiar and has experience in getting structures and districts designated in the National Historic Register.
There's no evidence on the record that there's a factual basis, is there?
He's testified to it.
Well, that's not my understanding of what the question was. He said it's there, but how would he know what the status of any application was? No one's put that foundation in the record yet.
Okay.
That's what I'm saying.
Can I ask a question before you go for ask your question, just to follow what he said, ask a question?
Yes.
Right, so, I struggle with this, we've been hearing this a lot, a gas station or whatever. And I understand we have a historic district further up a little bit. It is a commercial zone property. You said 21st century business, no one's gonna come and build a cowboy shop, with sling gun. This is, everything gonna go on that property will be a 21st century property. What is acceptable?
So we're talking specifically about signage right now,
No, but my point
but
to you is
yeah,
acceptable.
broadly, so I think a gas station could be acceptable. I think you'd want to be careful about that, how that gas station is designed.
Okay, thank you.
So, just laying down the foundation that, does the surrounding community have a potential impact on a designated historic district registered with the National Historic Registry?
Is there evidence that that's in the record?
As what is in the record?
The registered national, or that there's an application pending? Any of the factual basis that are part of your question? Has there been any evidence in the record
Go ahead.
about this?
So the Osborne Bennett Historic District is registered with the National Register of Historic Places, with the U.S. Department of Interior, and properties aren't inherently on the, or listed, listings aren't inherently on the register forever. They can be delisted.
And how do you know this? I mean, what's the basis of your knowledge for this?
So I've expanded a historic district in Central Falls. I did a project evaluating all the
I'm
historic.
talking about in this particular case, not in Central Florida.
Sure, so I looked at the nomination papers for this historic district that are on the Rhode Island Historic Preservation and Heritage Commission website, and I also looked at some material from the Secretary of the Interior about how they evaluate National Register applications and National Register properties.
And are you prepared to testify to when the application was made?
Just if I could, that information that he's speaking to was submitted to this board.
Well,
Sure,
I think, that-
right.
I mean, I don't know if it's just me. I need to know where he's coming from. Like, what has he done to make this relevant to our discussion?
Understood. I just want to make sure that this line of discussion was supported with.
I'm not saying it's a discovery violation. I'm saying he needs to explain it.
Sure, understood.
So the form that was attached to my report was prepared July 2001.
This one?
Yes.
I have a question, just for clarification. Are you saying that these 4 properties could be taken off of the National Registry because of this site?
Because of,
If a gas station were to go in this place, do you believe that one of these 4 houses, or all of these 4 houses, could be taken off the National Registry of Historic Places?
no, I doubt that would happen.
Okay. What are you getting at?
Okay, good point.
So one is I think it erodes the integrity of the historic district, which is one of the requirements for its listing on the National Register. The nomination papers talk a lot about Route 24 and how the construction of that eroded the integrity of the historic district. This is another thing that will erode that integrity. I think at some point, if you keep eroding the integrity of the historic district, then it might no longer be eligible for listing on the National Register. I also think it's, the board's responsibility in applying this criterion, looking at, sorry, I just want to cite it correctly. Compatibility with neighboring uses and affecting the general character of the area. The historic district is absolutely part of the character of the area, and I do think that this, as I just described, adversely affects the historic district.
But not necessarily take them off the registry?
Correct.
Now, in the context of that assessment of this project in the Osborne district, you visited the area, is that correct?
Yes.
And in your report, you provide a picture, and as I understand it, and correct me if I'm wrong, that you're standing in the district looking northbound towards the project site, is that correct?
Yes.
And in that picture, it happens to be dusk, there are taillights.
Yes.
So that's a significant distance away from, well, when I say significant, it's, whatever it is, 500, 300 feet away from the district, and you can see those brake lights from there, correct?
Right, you can see the glow of the brake lights.
So, is your concern is that from the district, you're going to be seeing the signage?
Exactly.
Okay. And, of course, for those people who live directly across the street from this project, we're looking at small taillights 300-400 feet away, whereas we're going to have some rather large signs within 100 feet or 200 feet of the residence. And I'm not going to have you opine about what that effect is, but have you seen any renderings from the applicant to show what those folks might see?
No.
Okay. And
Can I ask a question before I continue, because I'm really confused? He said it the second time he mentioned that, and I thought we addressed that. The second time he mentioned that they had not submitted a render to show the light, and our attorney, he's not here to say it per word, says to you, it is too expensive. If you want it, and you want to bring it up, you pay for it. That's the exact word he used, and somehow you keep mentioning in these questioning that have been addressed in different meetings. I know it's been a lot of meetings, you probably don't remember, but that specific question was said to you. It's not their job to show you how far the light goes from and how far people could see it. It's too expensive. I'm not defending them, but you keep saying it, and I'm saying to you, I don't want to, it's not a,
sure, so I get that, and I appreciate that point. As Mr. Friedrich said, it's the applicant's burden to demonstrate this is not going to have an adverse effect on the general character or have an adverse effect on people's health, safety, and well-being.
but it
And-
was addressed
and-
directly with you about this specific plan. If you want it, and you keep asking for it, you pay for it.
Well, true, or
Excuse me, the public cannot keep making comment and answer. Please.
Or the board can use their own sense and imagine that if you can see those taillights from that distance away, you might see imagine what those lights are. Now, you can say there's no evidence either way, or the applicant hasn't proven that it's not going to be adverse to the public's health, safety, and welfare and general character of the neighborhood.
I don't have any problem with the line of question of the lights and all that,
Yeah.
but talking specifically about the plan was addressed in previous meetings, month and month ago.
Understood. We're not going to produce it, it's too expensive. Whether they choose to produce it or not, that's up to them and this
I mean,
board.
there's no requirement as a condition of our ordinance that a rendering be provided by an applicant. There's no requirement for,
I understand that.
oh, do you agree that's,
I absolutely agree. All I'm saying is that there is a requirement in your ordinance that this project shall not have a detrimental effect on the public's health, safety, morals, and welfare. And it shall not have a detrimental effect on the general character of the community. If you feel there's sufficient evidence in the record that it does or doesn't, that's great. I'm just asking my witness if he has any information that can lend his opinion on that.
Yeah, just the point I'll make is, I don't think the board is often getting applications for non-conforming signage in view of historic districts.
So certainly, the board could ask for it if they wanted, if they felt that it was necessary for them to make their assessment.
Yes.
that's why we have our own legal counsel.
Sure. Okay. So,
Can I ask a question, please? When was this, when did this go on the National Register?
So it usually takes several months after the form is submitted. It's reviewed by staff at the Rhode Island Historic Preservation and Heritage Commission. There's a vote on it by that commission, and then it's forwarded to the Department of the Interior. So given that this was July 2001, it was probably listed by the U.S. Department of the Interior in 2002.
Okay, thank you.
and then lastly, with respect to the signage, if you could opine on the the criterion 6, which is the special use permit for signage consistency with the comprehensive plan.
Sure thing. And so the Tiverton Comprehensive Plan was adopted in 2018. It remains the legal framework to guide future development in the town. Signage is a very specific aspect of land use planning, and a comprehensive plan is a very broad document. So it's can sometimes not be the easiest thing to line the two up. Here, actually, Tiverton has some pretty good language in its comprehensive plan that relates to the considerations of signage. One of those is Action 8 of the Natural and Cultural Resources chapter. This action calls for aesthetic standards for commercial areas to encourage the creation of safe, attractive, and efficient centers rather than unsightly strips. And I think the town is working on that action with its signage requirements.
Okay.
And just, you know, referring more to that action specifically, there's an introductory sentence to it that states, "A great number of things make Tiverton a wonderful place to see, including beautiful landscapes, old buildings, and some attractive newer developments." And, you know, the proposed signage, it's not hideous, but I don't think it reaches to the level of what Tiverton is looking for in its comprehensive plan. There's also some talk in section 1 of the planning concept chapter referencing visual quality, which calls for celebrating the eclectic architecture of Tiverton, and that it be celebrated and complemented through new development exhibiting unique, high-quality design. And, you know, I don't think the logos need to change here. That's not realistic. But I think the signage itself, it does not rise to that level that the comprehensive plan is looking for.
I have at least the gentleman, it's a clarification, which is, I honestly, I appreciate you being here. And the town of Tiverton a while back said no more internally lit signs, which I was grateful for that. But let's say, we're not talking about in general. This internally lit sign, or let's say this sign have light pointed out to it. It's a monument sign with lights pointed out. Does that, in your opinion, have the same effect as an internally lit sign? Like, I have a problem with the LEDs personally, but that's because I'm not 21st century guy. So the question is the internally lit sign have the same effect on a historic district? The sign been lit with pointed lights on it? It's still gonna be bright. You're still gonna see it. But are we talking the same effect?
So, you know, I think what you would typically see in a historic setting would be a wood sign with painted lettering, and if it needs to be lit at night, that would have indirect lighting.
Okay, so,
There's a few other citations I have of the comprehensive plan in my report. I don't know that I need to call them out here, but you know, I just want to acknowledge the work that Mr. Pimentel did. I think his review of the comprehensive plan is very general. He's picked general language that's generally supportive of the project, and looking specifically at signage here, which is a design element. I don't think in reviewing that specific language that this criterion is met.
so I want to move on now to the special use permit for the gasoline filling station. Again, those 6 general criterion apply to this application for this special use permit, correct?
Yes.
Okay. So, what is your opinion with respect to criterion 1?
So again, this is public convenience and welfare. We talked about how there's convenience and welfare for the applicant. You know, there will be a gas station at this location if this project is ultimately built. For those that are in the vicinity and can walk to the gas station, you know, that might be helpful if they're mowing the lawn. There is another gas station just down Main Road. If you're looking for a Shell Seasons, there's a 24-hour Shell in Fall River, a few miles away. Also, a gas station, you know, you typically have a clerk. That's a low-wage job. There's going to be property tax revenue from the gas station. And yes, those serve the public convenience and welfare. There's drawbacks. One of them, as we've talked about, is visibility from the historic district. And also, I think gas stations in general, and looking at public welfare are problematic. We're burning fossil fuels that are heating our planet. Tiverton has a number of gas stations, and it's not clear to me why it needs another one.
And also,
Question, if I may. Are you saying that no gas stations would meet that criteria, or just Colbia?
So I think that's for the board to determine. There
Well, I
are,
think that's what you just said.
yeah, there's a number of gas stations in Tiverton. You have special use permit criteria. You have to evaluate whether any projects meets those criteria. If you have an expansion of an existing gas station, it's going to have to meet these special use permit criteria. My point about climate change is, why are you building more of what's creating this massive problem?
Well, the natural response would be because there's a demand. I mean,
That's how I make my living too, so I like it. No problem here. But
No,
my
no,
question-
no,
my
yeah,
question
I
to you,
get
you
it.
pointed
And
something out.
same with the applicant, yeah.
You pointed something out, we cannot take into consideration. We don't care how many gas stations in town. We cannot take that into consideration. So you just read that, and we cannot say there's a gas station up the street. I cannot say the gas station next door can consider in this application.
You can't pick and choose that. You can say there's too many gas stations in town and the public welfare is not being served, absolutely. Cobia could come in and buy one of the existing gas stations. There's nothing you could do about that.
But what I'm saying, when we review, unless I'm totally wrong, our attorney will tell me, if, in reviewing this application specifically, I cannot say my gas station next door to them. It's not my job. My job is to look at that application on its, on merit, not
Yes.
because there's more, excuse me, it's, that's what, okay, I just had an attorney. This is our job. We have to look at that station, doesn't matter how many gas stations are around it. That's our job.
I agree with you, you can't pick and choose.
Not pick and choose. I cannot say we cannot have another gas station.
yeah, we don't, I mean, it's not our job to put limits on the number of gas
It's not our
stations
job.
that can do business in this town. And for you to suggest that is sort of outrageous.
Well, maybe I could re-clarify. He is testifying that there is some public convenience, there is a public convenience to have a gas station. Yeah, because people need gas. The question is this gas station the only gas station to provide that public convenience? And I think he's indicated no. And I understand that you can't pick and choose if someone wants to come in and create more competition. I think he's just speaking to convenience only.
Yes, and I think an analogy would be housing. Towns limit housing construction all the time. They're not
That's
picking
our
and
job.
choosing.
That's not our job.
No, your job is to apply the criteria.
So, now, of course, with respect to criterion 1 and 2, we've spoken about the well-being, that is the public welfare, certainly those within 200 feet. And I'm asking you to make an appraisal of people's property, whether there's going to be a diminution in value or not. But if this project, there was evidence in the record that this did diminish the value of property around that, would that be consistent with criterion 1?
I don't think he's qualified to answer that
He's
question.
a planner, not a tax assessor.
He's already testified.
He can't talk about real estate values if he's not an appraiser.
Well, okay. If one's property value went down because of a project, would that be consistent with the public welfare?
Is that a hypothetical question?
He's already testified that valuation of property is a factor to consider on criterion 1 and 2. He stated that, and no one objected to that. That's in his professional opinion. And I'm just asking him to reassert that if this project resulted in devaluation of property, would that be inconsistent with the public's welfare? I'm not asking him to appraise anything, I'm not even asking him to make an opinion it's going to. I'm just asking if that's what the evidence reveals and the findings of this board, would that result in detrimental effect on the public's welfare?
Correct, and I believe there was consensus with attorneys and the board, I think a couple meetings ago to that point.
Okay, and so we'll be providing witnesses to this issue of valuation of property, to be sure. Okay, and then with respect to the third criterion for the gas station.
Yeah, I just want to point out in my report, the public health and safety issues of gasoline filling stations, and I don't think that should be ignored.
And, also, with respect to, climate change and people needing some way to fuel their vehicles, have you reviewed the site plan for this project?
Yes?
Are there electrical charging stations?
No?
And so, again, back to the third criterion, and I have to flip back to make sure I've got it right. Whether or not it's compatible with the neighboring uses and the general character of the area.
Yes,
And did you make that assessment?
I did.
Okay, what's your opinion?
Criterion 3 is not met. We talked about this with the signage. I think the gas station is just a whole nother level. This is a cookie cutter gas station design. I talk a little bit later about the mansard roof, but it's not really paying any sort of attention to what's going on in its surroundings. And I did mention the gas station up the road. I don't think that that's in and of itself emblematic of the area. This is primarily a residential area. There are a few commercial uses as you head north, but it's this kind of exurban line as you're heading towards Fall River, as roadside, small commercial operations. And what's proposed here is just, a large corporate, basically, get all your needs, stop.
Wouldn't that apply to any gas station?
No.
Why not?
So that this particular application, the way it's laid out, the design that the applicant has used.
You're saying that because of the design of the structure, they're different from any other gas station.
I don't know about any other, but I wager to say that there are gas stations on the National Register of Historic Places, and this is, I don't envision this gas station ever being on the National Register of Historic
Is
Places.
there a requirement that they have to be?
That's how I interpret this
They can't be the same as
criterion.
every other gas station?
That's how I interpret this criterion.
Really?
Yes.
So, Peter, I think what you had indicated before was that the comprehensive plan, one of their goals and policies, is striving for aesthetically pleasing architecture. Architecture that blends and complements the existing architecture and style of Tiverton. Is that accurate?
Yes, I get into this pretty substantially in my review of Criterion 6. I did grab some images of the Shell station next to Warwick Airport, which is pretty similar in design to what's proposed for this site.
Okay, so why don't you move on to criterion 6 in terms of its consistency with the comprehensive plan?
We talked earlier about public convenience and welfare. There will be property tax revenue from this, additional property tax revenue if this site is constructed. In terms of wages, that's not what the comprehensive plan is talking about. The comprehensive plan talks about high-wage jobs, economic sustainability, and, there might be some kind of regional jobs that support the corporate entities in this operation that are high-wage, but what's going to be on the ground is low-wage jobs. It's not providing additional disposable income to Tiverton residents, and it's not the kind of economic development that the town calls for in its comprehensive plan.
And just again, back to the architecture, you talked about this sort of corporate cookie cutter type of development. Is that consistent with the comprehensive plan?
No, I can repeat those elements that I talked about during signage, but,
I think
it's not unique, it's not eclectic.
Okay.
It's not what the comprehensive plan is looking for.
Thank you. And I guess to the extent that there was any testimony or opinion from the applicant's expert, I think that, do you have any thoughts about whether you have anything contrary to their testimony or opinions, or have you provided that in your testimony just now?
I have nothing to add.
Now, moving on, again, now to the last special use permit, which is the drive-through special use permit, the special use permit for the drive-through restaurant, correct? And,
Yes.
And you did an assessment of that drive-through service in terms of the criterion that needs to be met,
Yes.
okay? Okay, and so, with respect to, for example, criterion 2, what is your opinion?
So, in terms of criterion 1, my concern there was queuing, but I think the applicant can cross that threshold. As that relates to criterion 2, you have the added concerns of health and safety. There's been some talk about queuing, pedestrian vehicular conflicts, and that's enhanced by the drive-through. So I just think that the board should be very careful in reviewing this project and making determinations about this criterion, and to the extent that it can keep the travel speeds low and decrease vehicular pedestrian conflicts, that I think will help this project meet this criterion.
And so, we talked about, and I just want to draw your attention to, this is a June 6, 2023 DOT comment letter, which I believe we entered as an exhibit, or Karen? We did? You familiar with that, Bob?
No. Can you repeat that? I'm sorry.
Karen introduced these.
Yes, this was introduced and discussed at the last meeting.
Yeah, and I apologize, I don't recall which exactly exhibit it is, but I'll at least identify it.
That's why we have a problem with the exhibits.
Yeah, no, I get it, me too. But this is the June 6, 2023 letter from the DOT responding to the applicant's physical alteration permit. And it states, to your point of concerns of hazards, safety issues with respect to traffic and pedestrians, and maybe even vehicles. And it states here, this is item number 1, we tend to have many crashes in the state that occur at gas station locations, and a lot of those crashes have to do with improper access management. So, I take that.
Can I point out that there was a revision of that changed that comment? The second revision of that document? Did you know that?
Yes, so what they asked them to do is that you need to, instead of having, I'm going to answer your question.
Okay, let me just tell you that what they did was to change the comment to say that they had to separate the inlet and the outlet of the driveway on Main Road.
Correct. You're absolutely right. They had 2 entrances close to Sousa and one, I think, on the north side. And now they have 1 entrance close to Sousa and 1 exit further north. However, the germane issue that's being pointed out here is that crashes happen at gas stations. You can mitigate them, as this says, by controlling traffic, but the fact of the matter is, DOT has pointed out that you have a lot of crashes associated with gas stations, period. You can try to manage the traffic, mitigate and minimize those crashes, but the fact of the matter is, crashes happen at gas stations.
They also didn't recommend that the gas station not be put there.
They can't.
That's right.
All they can do is say, we see a problem, do the best that you can to mitigate the potential crashes, which they did.
Right. And-
Mitigate.
Yeah. Well, you put anything there and there's gonna be crashes.
Well, I don't want to get engaged in a colloquy, but if you go to a bookstore, maybe not. Right?
No, there will be crashes with anything there,
Well,
and even with nothing there.
you may be absolutely right, and, yes,
All right, I'll let it go.
Can you reread the sentence from the DOT?
sure. So,
The full sentence?
okay, the provided response to comment number 13 of the first notice of comments letter dated June 24th, 22nd, does not fully address our concern. please provide just additional justifications to why the 2 full accesses are needed on Main Road. 2 coming in close to Souza,
No, that's not what I'm asking. The full sentence
Yep.
that says about the
with the
crash.
southern access being close to the intersection, when there is also a full access driveway to Souza Road. We tend to have many crashes in the state that occur at gas station locations, and a lot of those crashes that have to do with improper access management. Please have the traffic engineer, well, I was gonna finish the sentence, because you
We're
asked.
finishing the paragraph. but
Finish the paragraph, yeah.
I just wanted that sentence.
Okay, right. So my only point is support of my expert's opinion that you need to be careful about traffic. DOT was also concerned about traffic, particularly traffic associated with gas stations.
Traffic associated with improper management of traffic,
No,
or crashes, rather.
no, I don't think it says that.
That's what the DOT says.
Of access.
Of access, yeah,
With improper access management,
correct.
right. So I think we've gone to the drive-through special use permit. You've got, did we address criterion 2?
We did, yes.
Okay, and criterion 3 and 4?
You know, in terms of talking about, just reference the exact language. Compatibility with neighboring uses, adverse affect the general character of the area, nuisance in the neighborhood. You know, with this type of use, drive-throughs, you have to be careful about litter. I think, you know, in the past, you saw more easily accessible disposal facilities for drive-throughs, and I think that this board should be very careful about this use in this area, and should, as part of its review, make sure that there are adequate disposal facilities and that the operator is routinely cleaning up litter.
I have a question. I mean, when I think of someone going through a drive-through window, think of somebody taking the items away from the site. So I don't see how litter would be something that would concern you about a drive-through window. It's not like that they're sitting there eating it and then throwing it out the window while they're in line.
That happens after they leave the drive-through window. So they pull off to the side, and you get people throwing stuff out of their cars.
That's kind of speculative, isn't it? I mean, not everybody walks out of it, drives out of it and throws stuff out the window. I hope not.
Well, I guess
I
maybe,
mean, I live like right near Dunkin' Donuts and this other place, and I don't see any particular amount of litter in the parking lots there. So I just, I mean, it seems like a kind of a general supposition rather than based on any kind of fact finding.
I disagree.
Fine.
I own a business right there, and all I do collect Dollar General stuff and Dunkin' Donuts stuff. So it is, I totally disagree and we try not to insert ourselves into any applicant. It is a problem. I've had 6 gas stations, and I know what drive-through could generate, and I know what store can generate, and one of the problems when we talked about Dollar General, the amount of trash. And that's what we do every day, and that's why I always talk to the town about Dollar General. So I agree with, there is a problem for that, but I don't know if that's, whatever. It's a problem all over the country, not just.
So I would just, encourage the board, have the conversation with the applicant. You just want to make sure that, to the extent you can, get ahead of that, so it's not an issue, 6 months after the facility opens.
well, certainly, the board and certainly the chair is, a little suspicious about your statement about litter, but you did cite in your report, the applicant's expert, repeat, the applicant's expert conceded that the operation will create litter. That was at the February 22nd, 2024 hearing transcript, pages 187 to 188.
Yes.
Okay. And I think also we discussed that when people are queuing at these drive-throughs, their cars are idling, generally speaking, correct?
Correct.
And that's creating pollution,
Yes.
and...
I mean, depending on the source of that idling, yes.
Okay. I think that actually covers everything, correct? Or you, something consistent with the comprehensive plan that you wanted to discuss on that?
Yeah, I think you touched on it. I mean, I don't think there's a lot that the board can point to there. So, to the extent that you can, having this be the best that it can be, I think is in everyone's interests.
And so, just to the point that's been raised before and by the board this evening, there's been a statement that, for example, the convenience store could be built as of right. What are your thoughts on that from a zoning,
I don't agree with that statement. This application is submitted for development, for a land development project with the Tiverton Planning Board, and any decision that this zoning board makes related to the other uses will go back to the planning board for a final determination of where on the site these uses will be.
Okay, so maybe this site could accommodate a convenience store, correct?
Yes?
Maybe it could accommodate a convenience store and a gas station, or not.
I don't think this application, the gas station can be approved.
Okay.
I could see a drive-through here. And, I don't understand the need for the non-conforming signage.
Very good. Thank you.
Does that apply to all the signs?
I believe it's the signs on the pumps themselves, the drive-through, the two freestanding drive-through signs, and the monumental sign at the front of the property.
The bad ones in your view, or the ones that are acceptable? I didn't understand.
So I think it's the applicant's burden to prove. I think the monumental sign with some tweaks could get to a place where it's appropriate. I think you need to think long and hard about the signage on the pumps. I think that's kind of expected, but.
What do you mean, like the price of gas?
Yeah, yep, yes.
Okay,
So
that's
you,
pretty
those,
much that's standard.
right, they tend to be LEDs now, and they used to be kind of those flip numbers, the printed books.
And they're not acquired, by the way, by law. They're not acquired.
Required, they're not
They're
required.
not acquired in the state of Rhode Island,
Okay,
which is one of my arguments. I have to give them credit that they have rolled some of the stuff. My problem with that station, just to add your thing, is the 3D canopy. That's more of a problem for me than just a pump.
Right.
It's by law, we could actually not require it in the state of Rhode Island. You need two places for prices, the monument and the pumps, and that's it, period.
Isn't that what he's talking about, the signage at the pumps?
No, he's saying.
I was saying the
but
signage at
We
the
don't even have to
pumps
give
at-
him that, it's not required by law.
I just want to make sure we're talking about the same
yeah,
numbers. Okay?
maybe I didn't realize that the price was going to be displayed on the roof.
No, I'm talking the pumps itself, do you complain about that LED over the pumps? In
Right.
Rhode Island is not required, so for us, it's like it's not required. They could apply for it, would say, no, because it's not a requirement, they don't have to have it.
But
In
there's got to be
Massachusetts,
price,
you have to have it.
you know when you're pumping gas, what number you're on and how much gas you've already pumped and how much it's going to cost.
Well, I think that's
Right.
required, right?
That's what I was talking about.
Right, no, it's the number above that, yeah.
No, the gas station owner is saying it's not required.
It is not required over the pumps. You have to have the price in two places. So if you have it on a monument sign and you have it on the pumps down, that's it. By law, that's the only thing they allow, they could easily fight over the pump. That LED is just a decoration. It has no legal value. They allow two places around that. So if they don't have it on the street, then they could have it on the pumps and inside the pump. Period. It's two places. So if we argue over the LED, which is, I had a problem with that. When they first started, I brought it up, and I said, I am not in favor of that. That gentleman, their lawyer said, we'll work with you on that.
And again, it's not, my opinion about, it's not my opinion about what signage is appropriate that matters. I don't think you can approve the signage. I don't think particularly the specific criterion too, it just, they haven't met that burden, they can't meet that burden. I think they could come in with a dimensional variance, and the board could talk about that, but that's not what they've applied for.
So you're saying that we don't have to tell them what's wrong with the sign, we just have to tell them that we don't like the sign?
No, I'm saying I don't think you can approve the signage. There's no basis. We're doing looking at criteria and
Is there a
too.
basis for not approving it? Just because you don't like it, I mean,
No, they don't have existing signage on the site, so they can't apply for a special use permit for signage.
you don't have a, yeah,
I mean, that's a legal question, not a planning question. I mean, am I wrong? That's soliciting a legal opinion.
Yeah, I think if I can succinctly describe what Mr. Friedrich has said, is that the burden is on the applicant to demonstrate that it's met the criteria. That's their burden. And what he's saying is that they have not demonstrated, for example, that if they don't get these non-conforming signs, that it's going to adversely impact their business, or it's going to somehow or another impact what they're trying to achieve. I think what he said is like, there's only one gas station in this area. How much signage do you need to effectuate, we're here, and this is what we're doing? And they have the burden to show, we need to go outside the scope of your signage regulations in order to achieve our intended benefit. And if we don't, we're going to be hurt. That's their burden.
but don't you think it's our burden to tell the petitioner why we don't think they meet the requirement?
At some point, you're going to have to.
Mr. Collins, it is your burden
That's
to
right.
state
If
the
it goes-
facts for why you're just approving or denying an application.
Because
So-
if it goes to court, we have to either.
The court has been very clear and has reiterated just last month that you must state the facts as to why you are approving or denying an
Yeah,
application.
Exactly.
You have your findings of
So
facts
what
and your
are-
conclusions of
What are
law.
we gonna tell them if we, at this point, we haven't been told why we should turn them down?
Can I answer that 1 second, David? I want to remind the attorney. Can-
Is this a question, I think our lawyer needs to step in on this. I don't know what you're arguing.
But we're
What
not,
are you
I'm
arguing?
trying to remind the attorney and David that this was discussed like 4 months ago, and their attorney already like really stepped aside and said, I'm changing, we're taking out a lot of the signs out of this application. It's, half of this discussion tonight was already addressed. Might not be totally to my satisfaction,
he's
but it was
not-
all, so the 3D canopy that bothered me with the shell on it, I know it's not called shell, whatever you guys call it, is unnecessary. The monument sign, we went through the signs on the driveway, and all this, and they, literally, he came the next meeting, the second meeting, and said, we're not doing this, we don't want this, we don't want this. So half of the sign you're arguing about, they already took them out of their application. Yes, yeah, I know.
Yeah, I can go through that on cross-examination.
Okay,
Thank you.
that's fine. At least the application, or the as it stands in terms of the signage, special use permits, and you can have that colloquy, Bob, I'm sure will, with Mr. Friedrich. Suffice it to say, we're going to be submitting some memorandums at the end, which is going to propose our findings and conclusions of law, and you'll have to do your job as to whether you accept ours or the applicants. And so I think Ms. Benson would like to do some further direct.
I was gonna ask, do you need a break? Okay, why don't we take 10 minutes? Thank you. Ms. Benson, do you want to inquire?
Thank you. Karen Benson on behalf of Preserve Tiverton. Very few questions, but the first one, I want to go back to what the chair asked at the beginning of your testimony. You talked about, she asked you about settings. What is the area of the neighborhood, Mr. Friedrichs? I think you have that on page 4 of your report. What is the typical size of the neighborhood you want to consider when you're looking at zoning applications and this kind of special use permit?
So I would say in this setting, it's, it's not a downtown. You would typically look at a half-mile radius, which is about a 10-minute walk.
Okay, so it's clearly more than just that 200-foot abutters radius when you're considering the neighborhood, fair to say?
The area, yes.
Yeah, okay, good. And you also say on page 4 of your report that setting is one of the aspects of the integrity of historic property. That's the Tiverton comprehensive plan, right? The use of that language, setting.
No, it's the attachment to my report, which is from the Secretary of the Interior.
Okay, thank you. That's the clarification I was looking for.
So that's how to apply the National Register criteria for evaluation.
Very good, thank you. So, Osborne Bennett Historic District, that question came up. What's the status of the district? Would it be fair to say that that is a matter of public record? You can look it up here in the state of Rhode Island because we have a statewide historic agency, correct?
Yes.
In fact, we also have a federal historic agency that handles these kinds of applications, don't we, here in the United States?
Right, it's under the duties of the Department of the Interior.
Okay, perfect. So theoretically, at least, the board could take judicial notice of the status. We could easily determine the status of the Osborne Bennett Historic District. Fair to say?
As a planner, I don't know how comfortable I feel answering that question, but it's on the state's website, preservation.ri.gov.
Well,
Okay.
I don't mean to be flip, but obviously, we need to have it on the record of these proceedings.
Sure.
So if someone wants to ask us about judicial notice or that's, you put the record together. We're not going to go out and do the research if that's
No,
what this
no.
witness was insinuating.
I'm just suggesting that it really isn't in dispute because the board had raised that question, and I don't believe anyone would contest that it's a current valid designation.
And it's in Mr. Hoole's report as well.
Thank you. All right. So that status is both state and national. That's just what I wanted to clarify.
Yes.
And you concluded, under Standard 3, this is just for the signage, I think you actually concluded for all of the standards that the applicant needs to prove to achieve a special use permit, that it was not in the public welfare to have this particular design approved, correct?
The non-conforming signage, correct.
Okay. And you indicated that you felt it would adversely impact the historic and residential aspects of this neighborhood, right?
Yes,
Okay,
of this area.
okay, area. Now, for the signage, you concluded it could, quote, erode the integrity of this historic district, did you not?
That sounds like what I wrote.
I just want to highlight that, because I guess my next question is, collectively, these special use permits, could they actually threaten the ongoing integrity of the historic district? Not just the signage, the whole application. Could it?
Yes.
I think Ms. Hilton asked this question. Could it actually have the historic designation removed? Is that within the?
Not these special use permits. I don't see that happening. This erodes the integrity of the historic district, these 3 special use permit applications. And if you look at the nomination papers for the historic district, they talk extensively about the impact of the construction of Route 24 in the vicinity of the historic district.
Okay, perfect, thank you. You're familiar with 36 CFR, Section 60.15? No?
Not off the top of my head.
That's okay.
That wasn't on the bar exam.
If I were to suggest to you that that is a provision in our federal legislation that is entitled removing properties from the National Register, you wouldn't dispute that, would you?
It makes sense that that would be
Yeah.
in CFR. 'Cause,
I previously-
I'm familiar with the practice.
I previously put this in the record, members of the board might remember that, on a cross-examination of another witness. The point is, as far as we know tonight, the evidence that we have before us today, it is possible, under the Code of Federal Regulations, for a historic designation to be removed. Yes?
Yes, it is possible.
Okay. And if I were to suggest to you that any person could petition the local government to remove a property from the historic district, you wouldn't dispute that, based
No, I-
on with the testimony from tonight?
No, I wouldn't dispute that.
Okay, thank you. That's all I have.
Mr. Friedrichs, may I call you Peter as well?
Yes.
Yes.
Good evening.
Soon to be a fellow member of the bar.
Maybe.
And my condolences as well.
Planners have better hours.
Yeah. Let's jump right into the signage. Did you reviewed the original application?
So I believe there was an application to the planning board. There was a amended application to the zoning board with different material. And there's been at least one amendment since then, I believe.
And were you at the March 20, 2024 hearing of this board?
I don't think so.
Did you review the record of that hearing?
I believe so.
Okay, and did you review the Dupree Engineering chart that summarized the changes made to the applications with respect to signage since the submission of the application?
If there's been more than one Dupree table, I don't know which one, if there's been more than one that I have reviewed.
Okay, and how many deviations from fully conforming signage is the applicant seeking?
Off the top of my head, I don't know the exact number.
All right, and if I told you it were 5, would that surprise you?
No.
And if one of them were related to the monument sign, and the only relief sought for the monument sign were the front yard setback and height, would that surprise you?
That's in line with what I remember about that request.
Okay, and the front yard setback, the applicant is requesting that it be put on the property line rather than 10 feet back due to the distance between the property line and the pavement, and that was in the record. Is that consistent with your memory?
Yes.
Okay. And do you know how many feet off the pavement the monument sign is?
Off the top of my head, I do not.
And if I told you it was in excess of 15 feet, would that surprise you?
Based on my review of the drawings, it would not surprise me.
Okay. And with respect to the height of the sign, how many feet on the monument sign and height is the applicant entitled to?
Off the top of my head, I don't know.
Well, okay, but you're testifying that the signage relief is over the top, was your phrase. So I'm trying to now understand why you say that. So if I said we agreed it wouldn't surprise you if it was 5 feet and we're asking for 7, would that surprise you?
Based on my review of the plans, that would not surprise me.
Okay, and if the 2 additional feet were to place a stone base for the monument sign, would that surprise you?
My response to that would be that, of course, you should put in a stone base in this location, and I don't think any relief is needed to do that.
Okay. What's the second area is, of relief is with respect to the drive-through board. And you're aware of how many drive-through boards are allowed in the town of Tiverton under the ordinance?
Are you referring to menu boards?
Yes.
So there was a lot of talk about that early in the project. What I recall is, or early in the hearings, what I recall is you're pretty close to the requirements there. And the way I think that the menu board was designed, I think maybe it was 2 and 1 was allowed.
That's correct. And with respect, and where are the menu boards located?
In the rear of the building,
Are they visible from the street,
not from Main
from
Road.
Main Road?
No.
Thank you. The canopy. There are 2 signs on the canopy, the pectins, the shell signs. And we've asked for we have asked for those to be internally illuminated, and they're approximately 3 feet by 3 feet each. Would that surprise you? But roughly the size of this, a little bigger than this table in front of me. Would that surprise you? Or do you remember that as from the application?
I think there are a lot of statements there. I do know that there are 2 shell signs internally illuminated on the canopy proposed in the application.
And while it's not signage, we have proposed that there be what's called halo lighting on the canopy. Is that correct?
Yes.
Okay. And are you familiar with the testimony and the colloquy with the board regarding Shell's criteria for internally illuminated shell pectins and halo lighting on canopies?
It's my understanding that the applicant was trying to meet the shell requirements for the design of their filling stations.
Okay. And are you familiar with the testimony the prior month where I asserted incorrectly, I asserted that that was a requirement, that I correctly asserted that that was a standard criteria for the Shell company signage and lighting of canopies? Do you recall that testimony?
That makes sense.
Right. And then do you recall Mr. Alzabak correcting me? And that at the March meeting, we recognized that one can apply for a waiver from Shell for that. Do you recall that testimony?
Sounds right.
And do you recall the applicant stating that if this board were to limit the halo lighting and the other signage lighting, we would seek that application from Shell?
Okay.
Does that sound correct?
Yes.
Or reasonable?
Yes.
Okay. Do you recall the testimony with respect to the lighting on the pumps where there was discussion about the so-called toppers, the additional LED pricing above or on the top of, that's why they're called toppers, on the top of the pumps? Do you recall that testimony?
Not specifically.
Okay. And do you recall the testimony where the applicant stipulated that the toppers, should they not be approved and be deemed too intrusive, could be removed? Do you recall that testimony?
That sounds right.
Okay, thank you. Now, also with respect to signage, it seems to me that your exhibits in your, well, let me step back. I'm going to still talk about signs, but in the context of this historic district, the Osborne Historic District. How many properties are in the Osborne Historic
I
District?
believe it's 4.
It's 4, and you testified you thought that that application was approved likely in 2002, when in fact it was approved in 2005. Are you familiar, did you review the approval?
So I reviewed the inventory that's on the RIHBHC website.
Okay. What's the impact of the applicant's application on the historic district? Is it that it can be seen from the historic district?
I would state that that's the primary impact, yes.
Okay. And what can be seen, so 3 of the 4 properties are on the same side of the street as the application, as the subject property, is that correct?
Yes.
And there's 1 across the street from where you took the photograph, is that correct?
Yes.
And in the proximity of the taillights, which my ophthalmologist will tell me is why I need a new prescription, because I thought that was a dot you placed there. But if those were taillights, you're saying that, is that the approximate location of the monument sign?
So, there's not a scale drawing here. I think you're going to be able to see the sign and the gasoline filling station from this location.
Okay. I don't think so, but based on that photograph in your exhibit, but so you're saying you can see the station, and that could diminish the integrity of the historic district?
According to what the Department of the Interior advises, yes.
Okay. Now, what about existing diminutions of integrity of the district, the current conditions surrounding the district? Isn't that a factor?
Yes.
Okay. So what about the Brookdale home right across the street? The Brookdale Assisted Living Facility, like right across the street and next door to the facility? Does that have any impact?
Yes.
Okay. And how many signs does that facility have?
I think there's a freestanding sign at the entrance to the property. It has a few different descriptions on it, I believe.
Right. Well, would it surprise you if I told you there were actually 2 entrance monument signs directly adjacent to or across the street from the district?
It would not surprise me, no.
Okay. And if they were comparable in size and actually comparable in height and wider than the subject application, would that surprise you?
No.
Okay. And those are lit with halogen lights facing the signs. Both of them are lit. Is that correct?
As I recall it, yes.
Okay. And are you familiar with how many parking spaces there are right next to this district in that assisted living facility?
There are a lot.
Would it surprise you if it was over 100?
No.
Okay. Now, the theme of the whole thing is, we had Mr. Pimentel, who you work with, according to your introduction of you as a witness. Mr. Pimentel basically said, here's a bunch of things I find consistent with the comp plan. And you said, okay, those are general, but so I have some specific things that are inconsistent with the comp plan. So this board's going to have to determine whether it believes one or both of you, but makes a decision as to consistency with the comprehensive plan. But then I'd like to focus on this a little bit. You said, with respect to the special use criteria on signage, that it's impossible to get a special use permit on a property in Tiverton that doesn't have existing signage because criteria 16.2.2, the establishment of a sign which is non-conforming by size will result in a clear visual improvement to a site by virtue of its replacement of an existing non-conforming sign. So is your position that unless there's existing signage, one cannot get a special use permit for non-conforming signage in the town of Tiverton?
Yes.
And then you said they should apply for a variance for that.
To the extent that the applicant's signage is not consistent with the zoning ordinance, because there's no existing sign on the property, it cannot avail itself of a special use permit, and if it desires non-conforming signage, it would require a dimensional variance.
All right, and if I were to tell you the town of Tiverton, at the time of the submission of this application, does not have a provision in its zoning ordinance for dimensional variances for signage, and signage non-conforming uses are sought exclusively by special use permit, what would you say to that?
So my understanding of the Enabling Act is you can apply for a variance for any dimensional requirement.
I don't mean to interrupt you, but it seems to me this is a legal question.
Oh,
This witness is really not, he's not an attorney, he's not qualified.
Okay, I'm just,
to do that. So
okay.
Correct.
Yeah, okay. But, so this is my point is this is the form and this is the application we're seeking because this is the mechanism the town has chosen for one to seek relief from the zoning ordinance. With respect to the physical alteration permit, that physical alteration permit was approved, was it not?
I believe you when you say that.
Okay, thank you. And I don't have any further questions. Thank you.
Anybody else? Would any member of the public wish to ask the witness any questions?
Just a couple of follow-up questions. So, there's been a discussion by members of the board and by the applicant about the special use permits being sought for signage. You reviewed a plan that's of record, correct?
Yes,
Those plans show the 5 deviations that the applicant is seeking, correct?
yes,
There's been a discussion here that some of this concerning issues could be removed, but not removed yet. Is that correct?
yes,
So there's been a request to have it removed. There's been a suggestion we'll work with you and have them removed. But as far as the application that's in front of you, that you're reviewing, that's what you made your opinion on.
correct.
Not what might be removed, what we hope to be removed, correct?
Correct, and it would be improper for me to make, conjecture about what might happen.
Okay. And so the 5 criteria that are in the plan, the 5 deviations that are in the plan, in your estimation, the applicant, as it's been submitted, has not met its burden that the signage criteria for a special use permit have been met.
Correct.
Okay. Now, just going back to the nearby signs in, I forget the name of it, some manor that's down.
Brookdale.
Brookdale. That's down by there, and there was discussion about signs and parking. So, if a historic district, in this case, the Osborne Bennett, has some qualities of nearby use that might detract from its historic qualities, is there a reason, in your professional opinion, that we should be adding more uses that could detract from it?
There could be a lot of reasons that a community seeks to detract from its historic district.
That they could detract from it?
I mean, that could be that's the community's choice to make.
Okay. So in this case, the community can make a choice. If they found that this project were to detract from the historic Bennett Osborne district, they could make that choice if they wanted to.
Correct.
Okay. And then I just conclude that based on all the testimony and opinions that you've given, you've made these with reasonable certainty and within the professional standards in your industry?
Yes.
Okay, thank you.
Thank you.
May I ask 2 questions on
Sure.
redirect? Peter, what zone is this property in?
General commercial.
And are you aware that the planning board has denied and that it was overturned and the court upheld the master plan approval?
Yes.
Great, thank you.
Anything else? If you have a question of the witness, you can ask the witness a question.
Hi, I'm Jamie French, and I live in Tiverton. I wanted to, I know you've gone over it several times now, but I wanted to go back to the historic district question to clarify, since I have written also submissions for historic districts. and lived in them, that there's a difference in your, would I be correct in saying that when a house or a property gets a historic designation, that is not relevant often to the neighborhood or the area of town that it's in. But when a historic district gets a historic district designation, that is because it does take in the surrounding trees, it takes in the open areas, it takes in the stone walls, it takes in all of the hardscapes and landscapes of that area, and that is one of the attributing factors for historic districts, as opposed to historic designated houses. Would I be correct on that?
Yes, I'll read the exact language to you from the National Register Bulletin, how to apply the National Register criteria for evaluation. And this is the setting section of integrity. It states the last paragraph, page 45, these features and their relationships, this is with regard to setting, these features and their relationships should be examined not only within the exact boundaries of the property, but also between the property and its surroundings. This is particularly important for districts.
Thank you. My second question is about lighting. Tiverton tends to be a bit dark, and so you're driving up the road and it's a dark area, and then suddenly you have this like lit humming thing, you know, come around and there's this business, and it's a very distracting, as would you say also that lighting can be a distraction for people driving because your eye tends to go that way. And being that we're not in a city where there's lots of surrounding lights, that a light from an isolated light is quite different than.
Yes, I would say that's one of the primary reasons for regulating signage.
Okay, thank you. And one of the things I haven't heard anyone talk about is the pollution from the idling of a drive-through. If you,
I'm not sure this is the witness to ask that question of. I don't think he's qualified to testify to that.
okay, well, because we had talked about idling, and with the heavy metals, I'm afraid that the,
He's not a scientist, he's a town planner.
okay, well, it does, well, my point is that because of the topographical situation and the prevailing wind of the area, it could affect the health and safety of surrounding properties because the pollutants could be moved about, and that would be a violation of our comprehensive community plan, wouldn't it, if health and safety was violated?
So the criteria related to public health and safety are not directly tied into the comprehensive plan. You know, I think the comprehensive plan makes broad policy statements about goals for the future of the community. I'll leave it at that.
I thought that, I'm sorry, I thought that the plan itself talked about the health and safety of the occupants of Tiverton being a concern to our health and safety as to, you know, to the rural character of our town.
So when you're looking at a comprehensive plan, it has a degree of specificity. The other two, the criterion 2 is really talking about public health. And so my statement is criterion 2 is the appropriate place to look at that.
Okay. Let's see. And would it be true in saying that there's only a certain amount of money that is spent on certain things, may it be gasoline or it may be coffee? And so when one business begins, it takes away the businesses from the other businesses, which is unimportant, but what I'm saying is that it does not increase, would it be correct in saying it does not increase tax revenue for the town because the residents are just choosing to spend their money the same money they would spend here than now spending here or here.
I disagree. I think more development in a town makes more property tax revenue, which is the
Even if-
primary source of town revenues.
So you think, so are you saying that there's more people will spend more money on gasoline if there's more gas stations?
That's not what I'm saying. That's probably true, but that was not what I said.
I'm sorry, because I'm confused. I just thought that there was, if you have like, you know, if 10 people have $10 to spend per week for gas, and,
This is not an appropriate question for
oh, I
this
well,
witness.
I thought that had to do with the comprehensive plan in that.
Well, you're not asking about the comprehensive plan.
Well, it is, well, I'm not, I am probably not asking my question appropriately because I see that as a rural community in the comp plan, which I've read much of, it's supposed to be a benefit for those of us living in the town. And new businesses are thought in the comp plan to bring in new revenue. But if we already, if there's only a certain amount of revenue in town to be spent, then, and you're not bringing in new revenue, I'm not sure that it would be a benefit to the town.
It's an impossible question. I mean, you're assuming certain facts, like there's no more money to be spent in town.
Well,
And that's not an appropriate,
Well,
Assumption,
if you have the same amount of people living in the town and they spend the same amount of money.
it's not a question for a planner. It really isn't. It's not an appropriate question.
Okay.
Okay.
Well, thank you so much.
You're welcome. Thank you.
Thank you.
Anyone else wish to inquire of the witness?
Steve Money, 1049 Main Road. Live directly across from this proposed gas station. Got two questions. By adding 3 destination businesses, with all the lighting that's going to go up, I don't even know the size of the lighting, the brightness, or the hours of operation of this business. Is that going to increase my quality of life or decrease it?
So you'll be able to visit those businesses, and I'm sure that will be a convenience to you, but you're going to be looking out, your front door at this business 24/7. It's not a 24/7 operation as it was initially proposed, but it will be open after dark. These types of businesses tend to be busy early in the morning, and going from what you have now to what will be there in the future, it's probably a net negative.
Second question. Have you ever seen a newly built gas station totally surrounded by residential homes?
I think that Mr. Hool had a good example of that in Portsmouth.
On all sides?
I think that's a difficult question to answer, off the top of my head.
That's all I got.
Does anyone else wish to inquire? Seeing no one, the questioning of this witness is concluded. And do you have someone else you want to call tonight, or is this?
No, Madam Chair, but I do have another witness. It's not an expert witness, and that's Mr. Steve Hendrick. We already submitted his report. I thought we would use our time wisely because this is already an exhibit. I'd ask him a few questions about how he did his report, what the report entails, what his experience is, and I'd end it with that. I've already discussed this with my brother, I'm not trying to qualify him as an expert. I know that's.
Well, I know there was a question about not wanting to go too far today. If you have somebody here that you're paying for their time, then I can understand why you want to present.
Are you paying for his time?
No, he's.
And this is the data analyst,
Yeah, I know.
data analyst witness whose whole opinion is as to value, and he's not an appraiser. So we submitted a memorandum objecting to
Right.
him. Ms. Benson's trying to slice the bologna pretty thin and say, well, I'm not going to present him as an expert witness, but I'm going to ask him questions as part of my opposition testimony. I have no objection to his report being part of the record, because he's a member of the community and he submitted some documents. I have no objection to him testifying as a member of the public when you hear public comment. But I do object to him being treated as if he were an expert, even if he's not qualified as such, where he's concluding under examination from counsel as to value when he's not an appraiser.
I think the case law is pretty clear. If that's your intention, your reason for putting them on.
So, we submitted 3 documents back in May 15th. And at that time, we had the report, the slide deck, and his CV.
Right.
And again, I'm not suggesting, I disagree with my brother that he gives an opinion. What we're saying is, and what the record discloses, is that he has experience, over 30 years of experience in aggregating data. That's what he's done for us. He's taken a bunch of information about property values and he's just presenting it. It's not an opinion. He has more than 30 years of experience in research. That's what he's done for us. These are complex issues, and so this member of the public has used his experience and his education. I would not, I'll stipulate, I'm not gonna ask him to give his opinion. I want the
Well, then
board
what
to
you want?
understand how he
Then
arrived
what
at.
probative value does the report have if he doesn't?
You can
if-
give it whatever weight you
Agreed.
deem.
honestly want to go home. I want to go home.
Then we'll let him testify as a member of the public. I wanted to use the time wisely tonight. I don't want to belabor it. He's here, he's taken time out of his life to come and join us. I thought I would ask the board to consider those.
Listen, I appreciate what you're trying to do, but
I
I
wanna
think the
use-
case law is pretty clear on, the reason you're wanting to put him in is basically for him to provide this board with data which can be interpreted relative to real estate values. And I think the case law is pretty clear that you can't do that. You can call it a pig with lipstick, but it's still a pig with lipstick. If you guys want to admit it as an exhibit and stipulate to it, we can
The
we can
report,
consider it.
the
for-
report was submitted, and we have no objection to the board reading it and considering it for the value on its face, but it's not testimony as part of the opposition's case.
Well, I guess the point is that it's part of the record, so if it goes up, it's in here. This is something that I think is within the sound discretion of the board. We can either, we can read it, we can find it not probative or relevant, or we can not give it a lot of weight because of the lack of qualifications of the witness.
Yeah.
Those are
Our view is.
I understand why you want it
Yeah.
in the record.
Our view is, for Mr. Romano's benefit, we have been, I think, very collegial and cooperative on the, and we've made a decision as the applicant and as opposing counsel to object as little as possible to what's in the record, that you're smart enough to discern what something is. I'm just objecting to him being part of the opposition's formal testimony questioned by counsel. He should be a regular member of the public.
Yeah,
I think
but-
that's a point well taken.
But he could go up to the podium one
Yeah.
night and just take 20 minutes. explain
Yes,
himself.
and I think that would be helpful for the board, because then you'd be able to pose questions to him about what did he do? Where did this information come from? And that's all I was trying to facilitate tonight. If there's a better way of doing it, he's a member of the public, I don't even need to ask him to come back. I'll assume that he's an interested member of the public and he'd like to join us. on
Okay, so
another
why don't we
night.
call it a night?
Thank you.
We have the report.
Yes,
Yes.
it came in on May 15th. The report, a slide deck, and his CV.
And then on July 8, we submitted to you a
Yes,
memorandum.
I know you both submitted.
Oh, I remember your.
No, I don't think we did.
They've reserved the right to counter our memorandum. We submitted a memorandum describing that exhibit, or describing that submission and objecting to it being part of the
Yes,
objector's
we have that.
opposition.
Okay, so why don't we admit Mr. Hendrick's report by stipulation, will be a stipulated numbered exhibit.
The whole package, the CV, and.
If that's
and
what
the
you're,
slide deck.
whatever you
Yep.
stipulate.
Yeah, but
that's-
that was submitted, and we didn't object to it at the time, we don't object to it now.
All
It's
right.
being part of the record.
Can I say something too? I I wanna ask you a question. I asked our attorney, and I mentioned it to the chairman tonight. I would like that one time, next meeting, maybe on the operating hours,
Yeah.
somehow fit them in your agenda.
We
I'd
have-
like
We're
to do-
gonna get to that, okay?
Yeah, I just want, I'm falling asleep. I just wanna get to it.
Yeah.
Soon, please.
Yeah, and we've also stipulated, and I didn't ask the witnesses about this, but we've also stipulated, we understand the board has the power to place restrictions on the
Restrictions on your hours, exactly. So I think that's, you can tell us what you propose, and then the board can discuss it in our deliberations and decide whether we think if your request is reasonable or not reasonable.
Exactly, yeah, thank you.
So, okay?
And we're gonna procedurally do the same thing we've been doing?
Yes.
Which is report a date?
Yeah, well, we're gonna put it down for the next meeting, which I think is, you know what, first Wednesday in October is? First
In
Wednesday.
September?
Is there a possibility you might have just to
sorry.
wrap up witnesses and commence public
I'm
testimony?
not putting it down for September.
4th?
No?
I'm not
Okay.
putting it down for September.
Okay, well, we'll submit, we're here
I
at
mean,
your
it's-
pleasure.
It's August 22 now.
October 2nd?
Yeah, why don't we put it on the October agenda? And that's just for a control date. And
She says, want to meet in September.
Nothing for September?
we have a regular meeting in
Yeah,
September.
okay,
This is-
just
I mean,
wanted
this
to be
is the
clear.
summer.
Yes.
We got a month left of enjoying this weather.
Agree.
And I don't know how everybody else feels about it, but, we've been coming in for special meetings, and, does everyone agree with that?
I agree.
Okay.
We're fine, whenever the board's pleasure.
Okay, why don't we put it down for status on October 2nd? You guys pick a date that's good for you in early to mid-October.
Ms. Benson's having some surgery, so I'm trying
Oh,
to,
I'm
in
sorry to
October,
hear
so
that.
we're trying to accommodate her schedule. I'm legitimately trying to help her schedule, but we'll work it out.
All right. Thank you. Motion to adjourn?
Second.
All those in favor? Granted. We're adjourned, 8:15. Thank you.